Hello everyone and welcome to RTO Doctor's live video on Facebook that should have been on YouTube, but due to some technical difficulties, unfortunately, we had to manage contingencies, as we would say in the vet sector. I might just wait until a few people can join us because I can see that there's been a little bit of confusion because I've been trying to organise where this live stream was going to go from in an effort to improve the quality of the video that you're seeing. If you are there and you can see the video fine and you've joined us, please send me a wave or let me know that you're there so that we know that there are people following. But first of all, I'd just like to say thank you everyone so far for your support in supporting the Enough is Enough campaign so far. It has got off to a great start and the momentum is really kicking in now, and it's not a time to be putting our hands down. We really need to continue to stand together and unite and really keep pushing for this agenda of an investigation into ASQA's regulatory practices, activities, and really get that audit happening from the Australian National Audit Office and any other investigation that Parliament sees fit. So I wanted to say thank you everyone for your support so far in helping us to get the numbers together for that petition. And I would just like to add, while we're on that point, that currently the petition's sitting at around about 849 signatures. It closes in 8 days, and so it is really, really important for all of us and all the work that we've been doing in the vet reform group. Also, I know ITECA have also been pushing for an investigation and the petition. There are people and stakeholders right throughout Australia's vocational education and training industry who have been pushing really hard for this petition, and so it would be great if you believe in the cause and what we're trying to achieve, that you support the Enough is Enough campaign just that little bit more, and you look at the petition, what it's about, what we're trying to achieve, and putting your name on there. Now, just a reminder, after our video a few days ago with Joanne Cornelius, the RTO owner from Victoria, who shared some of her experiences with ASQA and the AAT, and it was brought to our attention that there are some people going around some of the groups on LinkedIn and Facebook and other social media sites suggesting that the petition is a scam. And just once more, while we're waiting for people to join us, I just wanted to remind people that that information is false. The petition is actually a legitimate petition that was put together by a lawyer who is part of the vet reform group, and it is sitting on the Commonwealth Parliament website. It is a legitimate petition, and when you sign it, your details are not made public online, but they will be made available to Parliament once that petition closes. So I know that many providers around the country are quite concerned about the consequences of signing that petition, what that may mean for them in terms of their future regulatory actions and investigations and so forth. And so I just want to assure you that the details will not be made public on the petition website. You can share it, of course, if you want, and then that sort of identifies you that you have signed it or you support it. But if you don't share it from their public platform, then that's a completely different story. So thank you again for the petition. I will put another link in the comments, although Lauren, I can see you're online with us and you've joined us. Perhaps if you would like to add that petition link for us while we're talking live, that would be helpful. Otherwise, I'm more than happy to add it at the end when I'm addressing all the comments and so forth. The other thing that I wanted to briefly say while we're waiting for everyone to catch up and find us, seeing as though I'm IT challenged, anybody that knows me, by the way, knows that IT and geography are my two biggest challenges in life. If I have a volunteer who can come and help me set up my IT system so that I can do this properly live from the YouTube channel, it will save me a lot of headaches. And I'm sure that vet stakeholders around the country will be very grateful for your pro bono work in setting up my IT channels. But I did want to say to all of those people out there fighting fires or trying to save their assets and their lives from fires around the country, please take care. I know that there are a few vet stakeholders who wanted to participate in this particular video this evening, but because they're busy fighting fires and trying to save their property and their neighbours' properties, they're unable to be with us tonight. So to everyone around the country who is battling bushfires and trying to stay safe, please continue to do so, and know that this video will be posted online for you to watch at a later stage. We are all thinking of you, and we hope that you will be safe and well. I also just wanted to say thank you to everyone for the birthday wishes. It was my birthday yesterday, and many people have been thanking me, sending messages just to say happy birthday and everything, and hope that I had a wonderful day. It has been a wonderful birthday in the sense that I've had the opportunity to do one of the things that I'm most passionate about, and that is to advocate for our sector. Being the vocational education, training and international education sector. So thank you very much for your birthday wishes as well. I just wanted to let everybody know that for those of us who are coming forward very publicly, exposing our faces and our names, and putting ourselves out there publicly and saying enough is enough, that we are starting to receive some forms of intimidation and bullying from people who work for or represent the National Vet Regulator. We would like to say to those people that we know what you're doing, and we are seeking legal advice, and we will not be intimidated or bullied the same way that you may get away with that with clients and providers. You can continue checking out my profile, using your spouses, using your friends and family members. You can continue going in private mode to my profile, to other consultants' profiles, other people who are involved in the vet reform efforts. You may scare other people, but you are not scaring me. And we will be getting legal advice, and we are currently looking at a range of protections available to us. We have also included a Transparency International link to a number of our posts, and any communications that go out will also be transmitted to them. And we'll put a link to their website as well, so that people can see what that's about. But it's about protecting ourselves and everybody who is in this effort to ensure that the National Vet Regulator, the Australian Skills Quality Authority, is actually held accountable for the things that it has done in the past and the things that it continues to do. It's also about holding accountable those ministers in Parliament, currently sitting in Parliament, who have had some of this information that we've been holding on to quite quietly, for want of a better word, for several months now, in an effort to, in good faith, assist the regulator to address some of the concerns that they need to address in order to achieve real reform in the vet sector. For those ministers who have had that information available to them, I can honestly tell you that if I personally do not receive any correspondence or follow-up from the communications that I personally gave to you in the last few months, that information will also be going to a number of organisations to make sure that you are held accountable for your failure to act on the information that's been provided. That's That's not a threat in any way, shape or form. It's just saying, you know what, I've had enough. I've been giving this information in good faith on behalf of a number of people in the vet sector. I was promised that something would be done about those particular issues, and as far as I can see, not only has nothing been done, but I still have not had any correspondence or acknowledgement of correspondence that I sent out almost 1 month ago. So this is just a heads up that if I don't hear anything by the end of this week, being Friday, what's the date on Friday, somebody? Today's the 12th of November and it's Tuesday, but if I don't have anything in writing from somebody saying, we'll listen to what you've got to say and we will do something about what you've got in terms of evidence, then I will personally make sure that that information gets released, and it will be quite damaging to everyone involved. I also am going to look at quite a few notes today to keep me on track, because the information that I would like to share with you goes across multiple places, and I may just get a little bit sidetracked if I don't stick to my notes. But basically the topic of today's video is in relation to ASQA ghost RTOs, or ghost colleges as they've been called, and the Callinan review and the links to the 7:30 report that we saw on the ABC on Wednesday the 6th of November, almost 1 week ago today. So we will be talking about those things and how that all sort of matches up with the Enough is Enough campaign, and I would encourage you to share this amongst your networks so that everybody who needs to see this can get to see it. This video, like all of the others that we're producing as part of the Enough is Enough campaign, is part of the public interest. We firmly believe that the Australian public and taxpayers are not being told or being provided with the information that they are entitled to receive in relation to the crisis in Australians' vocational education training sector and the international education sector in Australia. We believe that through the stories that you receive from the media, the stories that you see through the Australian government, and the stories and media releases that you see from ASQA themselves don't actually provide a full and accurate picture of everything that is actually going on. And we believe that as Australian taxpayers supporting these efforts, you have a right to know what's going on. And because we can't rely on other methods for you to receive this information, we have taken it upon ourselves now to make sure that you get that information as soon as possible. So I wanted to also clarify something in relation to the first interview that Alex Schroeder from Vet Prep and I did. I think it was on Thursday night last week, in relation to the 7:30 report, and the person who I did not name in the interview because I hadn't spoken to her, but I am happy to name now because I have spoken to her. I was referring to Larissa Kernborn, and I wanted to make it very clear that when I personally sat in the ABC interview with Paul Farrell at the ABC building in relation to this story, Larissa did not say the things that came across in that interview. It may have occurred at a different time, but I can certainly vouch for the fact that the issues that Larissa identified during the interview when I was sitting there in the ABC building in Perth were not at all aligned with the way her story was portrayed in the 7:30 report. Larissa actually gave a story, and well, many stories actually, and provided many examples of conduct that is unbecoming of a national regulator, and was very supportive of the Enough is Enough campaign. And I feel that it's appropriate to make it very clear at this point in time, especially seeing as though she is also one of the people who has been bullied and intimidated, not just by ASQA, but by the vet community also. Many people in the community have been saying and doing things that are not very professional. And I think it's important that people do know the truth, that Larissa was very supportive of the Enough is Enough campaign. Her stories that she relayed to Paul Farrell were unfortunately not communicated, and I can personally vouch for the stories that she told in front of me were not the stories that you saw on the ABC 7:30 report. It is clear to me that Larissa did an additional interview with Paul, and I do believe that the issues that we're going to discuss in today's video will also clarify some of the positioning around why Larissa was picked up saying the things that she did. Now, I, of course, don't know the reasoning behind why the ABC took the position that it did. However, what I do know is, again, and I will repeat this, and I hope that the video clarity is much better today, because I know the first time I said this, the video dropped in and out and it was terrible quality. But what I would like to say is that the ABC could have chosen to run a very different story, and it didn't. And I think what is very telling is that just today, almost a week after publishing that 4-year-old story, the Australian Skills Quality Authority has released a consultation document on full cost recovery implementation in 2020. For those of you who are not aware of it, I know that Brett Hilder will be releasing an article a little bit later today. He may even do a video himself. I'm only going to touch on this very briefly, but I find it fascinating that the story told by the 7:30 report was very different to the story that they could have chosen. Less than a week later, the consultation paper for the full cost recovery guidelines are released for consultation. We've also had, in the same time frame, the Commonwealth Government confirming that they will be giving ASQA a further $18.1 million to implement the Joyce Review recommendations in relation to a more educative approach to regulation in Australia. And it's also important to understand in that context, and I'm happy for someone to put together the statistics on this. I don't have them with me right now, but they're definitely available in the ASQA annual report, available on the ASQA website, and that is the number of compliance monitoring audits that have been undertaken in the last financial year have significantly increased. Now, the importance of that is that a compliance monitoring audit is actually fee for service, and you pay an hourly rate for the auditor or auditors, however that may be. What we're finding is that more and more audits are being conducted by more than one auditor, and therefore the fees and charges are charged at an hourly rate for each auditor, and therefore it is already full cost recovery. Although, having said that, I know that there are some nice surprises in there. Brett and I were talking about it earlier, and it does put further pressure on issues to do with access to merits review, an issue that I did talk quite a bit about in my book, launched earlier this year. I think it was around July or August. I don't even remember when I launched it. But it would appear that the consultation paper on full cost recovery is referring to charging or proposing to charge RTOs a sum of money in the thousands of dollars to be able to take ASQA to the AAT for some sort of review application. Now, I don't know all of the detail around that. I do believe that Brett will be writing about that a little bit later. I haven't yet had an opportunity to have a good look at the discussion paper that they have, or it's not a discussion paper, it's a consultation paper. I haven't had a chance to review it fully yet, but I do suggest that everybody with an interest in ASQA's full cost recovery process, if you are an RTO owner, that you do take a look at the full cost recovery consultation paper and make your thoughts known. There are a range of questions on the ASQA website where you can provide feedback. That was released today as well, and I really do encourage you to take a look at that. Without further ado, I would like to go back to the 7:30 report and the Callinan review that was tabled in Parliament on the 23rd of July 2019. Now, the reason why I'm bringing this up again today is thanks to the ABC report that aired, the 7:30 report, in relation to the ghost colleges that were alleged. Well, they're no longer alleged, I believe. The guy was actually convicted and jailed, from what I understand. But it was called School Scam or something like that. What I wanted to talk about was that was actually the final piece of the puzzle that brought it all together for me to be able to discuss this particular issue. So in December 2014, ASQA and the Australian Federal Police commenced Operation Aristotle. And this is factual information that comes to you directly from ASQA's response to the 7:30 report. So this is not me and my words. This is ASQA's direct statements that I have copied out here and that I'm reading to you. So in December 2014, ASQA and the Australian Federal Police commenced Operation Aristotle, a joint investigation into intelligence regarding possible fraudulent activity. Evidence gathered through this joint operation that included audits of each provider led to the convictions of Baljit Singh, Rakesh Kumar, Mukesh Sharma and Rekha Arora, and to the closure by ASQA of the St. Stephen Institute of Technology and the Symbiosis Institute of Technical Education. The outcome of this operation demonstrates the effectiveness of ASQA's scrutiny of these providers. Now, I have no doubt that there were issues in relation to fraudulent activity. I'm not going to even suggest that there wasn't. But what I do want to talk about is some of the implications of that statement in relation to what has previously been disclosed by High Court, the former High Court Judge Ian Callinan in the Callinan review, and ASQA's statement or media release to Tim Dodd from the Australian newspaper on July 25th, 2019. So if you, and by the way, the AAT review by former High Court Judge Ian Callinan is available on the Commonwealth Government's website. I'm also happy to upload a link to that for people in the comments. But it is very interesting in chapter 6 and paragraph 96. I'm going to read what the Honourable Callinan had to say about his interview with the Australian Skills Quality Authority. The acting head of ASQA called on me in person to discuss the experience of ASQA generally. She told me that delays in making decisions had repercussions beyond the AAT. ASQA was aware that organised crime was sometimes, perhaps even regularly, benefiting from counterfeit vocational training programs and colleges. There were, for example, ghost colleges, little more than addresses operated by people who provided no real training or tuition. Their students were not bona fide students. Often the so-called provider would find a job for the foreign entrant, charging commissions to both the employer and the so-called student employee, and arrange, again at cost, the transmission of funds to the student's home country. Now that is in the Callinan review of the AAT. It was tabled in Parliament, as I said, on the 23rd of July this year. Now, I'm not saying that ASQA should not be regulating. Don't get me wrong. I am not saying that what they did in this case was wrong. I agree 100% we need a regulator, but we need a transparent regulator, and we need a regulator who does their job properly in accordance with the standards for vet regulators 2015. They are accountable, they are transparent, there is no corruption, there is no conflict of interest whatsoever, and the system just operates, and people are honest and transparent. That is really ultimately what I'm referring to here. Now, it's really important that you remember that the acting head of ASQA in the Honourable Callinan's report made it very clear that he was referring to ghost colleges, she was referring to ghost colleges and criminal repercussions and so forth. Yet on the 25th of July 2019, there was an article printed in the Australian newspaper by Tim Dodd. Regulator denies ghost college claims. Now, I'm just going to read out a couple of things here from you, and I will put the link to that article in the video as well. The National Vocational Education Regulator has disputed the accuracy of former High Court Judge Ian Callinan, denying it had said, as quoted in the new report from Mr. Callinan, that organised crime was reaping profits from bogus training colleges. In his 195-page statutory review of the Administrative Appeals Tribunal released on Tuesday, Mr. Callinan said the Australian Skills Quality Authority's acting head had met with him and explained how delays at the AAT were affecting the regulator's work. Now, there is a quote there directly from the Callinan review. And then it says, an ASQA spokeswoman yesterday confirmed a meeting had taken place between the authority's Deputy Commissioner Saxon Rice and Mr. Callinan. But she denied Ms. Rice or any other ASQA official had made the comments which are quoted on page 88 of the review. Ms. Rice was unavailable to comment yesterday. Now, one of the things that really concerns me about this particular issue is that it is effectively an allegation that the Honourable Ian Callinan was lying in the tabled report that he tabled in Parliament. It remains completely unknown to me why someone would think that a former High Court judge might lie to Parliament in relation to a submission that was made or not made in relation to a review of the Administrative Appeals Tribunal. That's one issue. But then the second issue, quite separate to that, is all of a sudden we have a 7:30 report on the ABC on Wednesday, the 6th of November 2019, which ASQA, with the acting Chief Commissioner Saxon Rice being responsible for today, has released a statement saying that in December 2014, which is prior to the Callinan review, ASQA and the Australian Federal Police commenced Operation Aristotle, a joint investigation into intelligence regarding possible fraudulent activity. I'm going to repeat this again. Evidence gathered through this joint operation that included audits of each provider led to the convictions of XYZ people and to the closure by ASQA of the St. Stephen Institute of Technology and the Symbiosis Institute of Technical Education. And then they had the denial, of course, of the ghost college claims. So what I'm trying to explain here is that the information that was provided to the Honourable Ian Callinan at the time of the Callinan review, when it was tabled in Parliament on the 23rd of July 2019, which I also talk about, by the way, in my book, it was at all times absolutely true. And we've just seen the evidence of that. What I had written in my book is on page, let me find it. It's on page 43 of my current book, and it comes under the heading, the audit process. And what I'm talking about is the Braithwaite report, identifying that there was a real need for transparency around ASQA audits to inform the sector on where systemic weaknesses lie. I was talking about critical concerns that have not been discussed in this particular book, and referring to further investigations that had been undertaken by people including the Honourable Ian Callinan, in which his work was completely rejected. So that was one of the things that I raised in this book. You'll notice that there's a few little tags here, and I'm going to bring these out into the open as well. One of the other things that was stated in ASQA's response to the 7:30 report, and again, we will put that particular link there again is that the AAT process is one of merits review, which is great because that's actually what this entire book is about, access to merits review under the MVR Act. The AAT process is one of merits review where providers are able to submit additional evidence that non-compliances have been addressed subsequent to ASQA's decision. Now, what that doesn't tell you in ASQA's statement, and they will never tell you, is that often access to merits review is only undertaken because the original decision was based on flawed legal decision making. That is an issue that I talk about in this book. Now, just because ASQA says something is not compliant does not necessarily mean that that is true. What we find often is that people have to go to the AAT just to prove that ASQA were actually wrong in the decision that was made, or the decision that was made was based on evidence that was not even reviewed or was made available. And there's a whole range of reasons why that decision that was originally made by ASQA was wrong. And it's not always, as per this statement by ASQA in responding to the 730 report, that the non-compliance has been addressed subsequent to ASQA's decision and the review of the decision by the AAT was correct. What this actually says is, as such, the review of a decision by the AAT is not one of whether the original decision was correct, but is a process of considering what the correct decision is at the time the AAT makes it. So what people are actually having to use the AAT for in ASQA matters is to prove that the decision that was made by ASQA is in many cases actually based on a flawed foundation, and it was never not compliant to begin with. Granted, there are some cases where ASQA's decision is actually correct, and we applaud them for that if it is actually correct. But in my experience, going to the tribunal with a number of providers, what I find is that often the decisions that are being made based on a flawed foundation. And I do address that further in the book. In greater detail, and I provide examples of case law where that can be evidenced as well. So I think it's really important that we understand that just because ASQA says something is not compliant, it doesn't automatically mean that when a client goes to the AAT and the AAT makes a decision that means that the non-compliance is no longer there. ASQA will often tell you that it's because the RTO made rectifications to the non-compliance. But more often than not, what we find is that the non-compliance was never there, and we have to scramble and produce evidence to prove that we were not guilty, even though we've been deemed guilty before we even get to the tribunal. It's very much against Australia's legal system, whereby you are supposed to be innocent until you're proven guilty. In the situation that we have with ASQA, everything that comes out at the moment is you are guilty until you're proven innocent. And that is actually why people are going to the tribunal. They are going to the tribunal to prove that they're innocent, not to say that they're guilty or defend their guilt. One of the other things that I wanted to pick up here was the majority, and again, this is from the statement that I printed off from ASQA's response to the 730 report. So you can follow it there. Again, I will put the link here. But the majority of these, 53%, were resolved between ASQA and the provider, inevitably following the submission of additional evidence that identified the non-compliances leading to this decision had been rectified. Again, this just reinforces the point that I was making just before, that a provider is having to use the tribunal to demonstrate their innocence and they are found guilty. And when they're going to the tribunal, all they're doing is providing evidence of the flawed legal decision to begin with. And it's not necessarily rectification when they're doing that. All they're doing is they're proving their innocence. Just because they have to provide a whole lot more evidence, it doesn't mean that it was rectification of a non-compliance. It also says that a significant number, 29%, were withdrawn by the applicant. What I want to pick up here is something that is not often spoken about, and I do speak to it in the book in relation to breaches of model litigant obligations and the APS Code of Conduct and things like that. But what we find is that there is a significant number of providers who do withdraw from the process at the AAT, and that is because as much as the AAT is a mechanism of review for providers to submit new evidence, it's also an opportunity for ASQA to submit new evidence. And that is something that ASQA seems to be taking advantage of a lot in tribunal matters at the moment. What we're finding is that ASQA will make a decision, and when a provider goes to the tribunal, often they'll be hit with unexpected Section 26 notices, which are requests for information and production notices and all sorts of things, and they'll bombard them with a whole heap of information and evidence. And the ability for a provider to then support in time, energy, resources, both people and financially, the case that has suddenly gone from being something small to something that has just blown out in size becomes so significant that they can no longer afford financially to continue the process of seeking merits review. And so when people are reading figures and statistics such as a significant number, 29%, were withdrawn by the applicant, you should not for a second believe that the only reason that they are withdrawing from that process is because they feel that they've been caught out, because in my experience, that is actually the least of the reasons why. The people who have been caught out, in my experiences, are the ones who will actually continue to fight the fight quite a long way, because they do have the ability financially to support themselves. Now, that's not to say, and please don't take this out of context, that is not to say that anybody who makes it through an AAT matter is a fraudulent provider or a rogue provider or anything like that. There are many RTOs out there who do go through the AAT process, and they are financially viable, and they have every ability to fight that legal fight without compromising their RTO operations. It's just that some businesses are smaller than others, some businesses have more financial capability than others, but the significant number that ASQA refers to of 29% were withdrawn by the applicant is not a reflection of those people walking away because they've done the wrong thing. It is more likely to be a reflection of they have been forced out of the merits review process. If I take you to page 73 of my book, one of the comments that I did want to bring to your attention, because it is absolutely what the Enough is Enough campaign is about. It's by Senior Member Puplik in the Administrative Appeals Tribunal, and he is quoted in the case of Australian Vocational Learning Centre Pty Ltd versus ASQA as saying, regulatory bodies are established in part to ensure that the public interest is protected in the areas of their competence, and the tribunal should be cautious about taking steps which may derogate from the protection of the public interest by failing to give due regard, although not unqualified deference, to their assessments in such matters. And my comments directly after that quote from Senior Member Puplik were that it is the contention of this paper and this book that Puplik's comments could not have been more appropriate. While his intention was not meant to question the competence of the vet regulator, what we're suggesting through the Enough is Enough campaign is that his comments should now be considered in this regard, particularly given the substantial tax dollar payers being absorbed by ASQA in this process. That was one of the other things that I wanted to mention. But then when we go to the model litigant obligation that lawyers have under the Legal Services Directions 2017 Commonwealth legislation, I just wanted to read out what that obligation is, because I don't know that many people truly understand what it is when we're referring to breaches of the model litigant obligation or potential breaches of it. I know that we spoke a little bit about it in the interview with Joanne the other day, and for that reason I do want to bring it to everyone's attention and I will also put a link to this in the video. But the obligation to act as a model litigant requires that the Commonwealth and Commonwealth agencies act honestly and fairly in handling claims and litigation brought by or against the Commonwealth or a Commonwealth agency. And there is a reason why I am going through this as well. It will come up once I've finished going through this with you. But some of the issues, and they're labelled as subclauses. Yep. So we've got dealing with claims promptly and not causing unnecessary delay in the handling of claims and litigation. Making an early assessment of the Commonwealth's prospects of success in legal proceedings that may be brought against the Commonwealth and the Commonwealth's potential liability in claims against the Commonwealth. Paying legitimate claims without litigation, including making partial settlements of claims or interim payments where it's clear that liability is at least as much as the amount to be paid. Acting consistently in the handling of claims and litigation, endeavouring to avoid, prevent and limit the scope of legal proceedings wherever possible, including by giving consideration in all cases to alternative dispute resolution before initiating legal proceedings, and by participating in alternative dispute resolution processes where appropriate. Where it is not possible to avoid litigation, keeping the costs of litigation to a minimum, including by not requiring the other party to prove a matter which the Commonwealth or agency knows to be true. Not contesting liability if the Commonwealth or the agency knows that the dispute is really about quantum. Monitoring the progress of the litigation and using methods that it considers appropriate to resolve the litigation, including settlement offers, payments into court or alternative dispute resolution. Ensuring that arrangements are made so that a person participating in any settlement negotiations on behalf of the Commonwealth or a Commonwealth agency can enter into a settlement of claim or legal proceedings in the course of the negotiations. Not taking advantage of a claimant who lacks the resources to litigate a legitimate claim. And I highlight that because it happens a lot. Not relying on technical defences unless the Commonwealth's or the agency's interests would be prejudiced by the failure to comply with a particular requirement. What we often see, and this is something that I refer to in the book in other areas, is when a matter is lodged with the AAT for a stay and a review of the decision, it's automatically sent to ASQA's legal team, but the person applying for the stay and the review decision may not necessarily always be represented by a lawyer. They may be self-representing. So what we always find in these cases is that we have people who are self-representing against legally qualified lawyers and barristers, Commonwealth model litigants, and it's not always pretty. In fact, if you go through case law, you can have a look at some of the outcomes of those people who have tried self-representing against the Commonwealth regulators' legal team, and the results are not very successful at all. Some of the other issues include not undertaking and pursuing appeals unless the Commonwealth or the agency believes that it has reasonable prospects for success or the appeal is otherwise justified in the public interest. Now, that is a really important one that I want you to remember, because it's going to actually have a critical impact on what I'm about to tell you next. So please remember that part of the model litigant obligation under the legal services directions is that not undertaking and pursuing appeals unless the Commonwealth or the agency believes that it has reasonable prospects for success or the appeal is otherwise justified in the public interest. And apologising where the Commonwealth or the agency is aware that it or its lawyers have acted wrongfully or improperly. These are some of the issues that I want you to remember from the model litigant obligation under the Legal Services Directions 2017. So why am I bringing this to your attention now? It has come to my attention that the matter of Brighton Pacific, ASQA has lodged an appeal of the AAT's decision in the federal court. Now, I have to provide a disclaimer here. I have got nothing to do with Brighton Pacific. People will be familiar with the article that I wrote on LinkedIn in relation to their particular matter, accreditation in the vet sector. It was also bonus content in the print copy of my book. So I've got nothing to do with that. I don't know all the facts of the case, but what I do know, I have actually written and provided publicly on LinkedIn and in my book, and I will post the link to that article once again in the comments. But what I wanted to bring to your attention was that in that article, I made it very clear that the issue around Brighton Pacific was in relation to international students who had been enrolled into a diploma of nursing that was not endorsed by or accredited by ANMAC, and therefore they could not get registration as registered nurses because the course was not approved by ANMAC. Now, there are very specific requirements around registration of courses that have got additional licensing and accreditation requirements when you are an RTO. And one of those is that before you can deliver that course, it must, and I'm specifically referring to ASQA accreditation requirements, but when you are wanting to deliver a course that requires additional licensing or registration under ASQA's banner, you do at all times have to have authority from that particular regulator before ASQA is supposed to approve it on scope. Now, what would have appeared to have happened in that particular case was not only did Brighton Pacific have the ability to deliver that qualification diploma of nursing on scope, but they were also able to then subsequently register that course on CRICOS. Now, for a course to be registered on CRICOS, it also has to go through a review process and have that same endorsement and everything signed off. It must meet the requirements of ANMAC and the training package. The training package is very specific and explicit about the ANMAC requirements and meeting the accreditation requirements for ANMAC endorsement of the course. And so what I want to point out in this particular case is that at all times it was ASQA's responsibility in approving that course on Brighton Pacific's scope of registration and CRICOS registration, that it was at all times ASQA's responsibility to endorse and confirm that they had that endorsement before they approved it on their scope and on their CRICOS registration. So for those of you who don't quite understand, because I think I'm confusing the situation more than it needs to be, basically what I'm saying is that ASQA has a responsibility to make sure that you have all of the approvals to deliver a course before it approves you to deliver a course. But in the case of Brighton Pacific, they had allowed Brighton Pacific to deliver that course not only to domestic students, but to a significant number of international students who had come from Australia. And then they came and said, oh, you're in trouble, you've done the wrong thing, we're going to cancel your registration because you didn't receive, you didn't get ANMAC approval for your courses. But the reality was it was actually ASQA's responsibility to do that before they approved the course on CRICOS or the college's RTO registration. So I think what's important for everyone to understand here is that when ASQA does go to the federal court, what the federal court must understand is that this is actually a case of ASQA should not be appealing this decision because they were always in the wrong to begin with. Now, if you want to understand this a bit better, and like me, you're a visual person, I have actually outlined all of the standards and where each of these different things is pointed out in the article, so you can see it visually. I've actually put arrows and everything that point to all the different standards. But again, I just wanted to point out to you that as we saw in the model litigant obligation, and I'll read it out again, that particular clause, the national regulator should not be undertaking and pursuing appeals unless the Commonwealth or the agency believes that it has reasonable prospects for success or the appeal is otherwise justified in the public interest. What is in the public interest in this particular case, in my personal opinion, is that ASQA were never right. They were very quick to point the finger, but actually the finger should have been pointed at them. The public interest is that the public is about to pay, and the Australian taxpayer is about to spend a significant sum of money sending Brighton Pacific to the federal court for a court case that ASQA was always wrong about. So that's where I was going with that. So what I wanted to come back to, and this will be the final point of my video for tonight, the statement on the 730 report from ASQA clearly states, ASQA refutes any suggestion that it makes incorrect decisions to cancel a provider. I think what you will see as you work through the example in the LinkedIn article that I published quite a while ago, or if you do have a copy of the book, you will see it also in there. You will see that in that particular case, that was an incorrect decision. And again, I'm not a lawyer. I'm a compliance specialist that works in this sector, and I work with this legislation all day, every day. I might be studying law, but I'm not a lawyer. This is not legal advice by any means. I do provide that disclaimer, but I'm just telling you like it is in my reading of the standards and why enough is enough. The final statement that I wanted to make, and this is going to be a big shock to some people, ASQA finishes their response to the 730 report by saying that it refutes any suggestion that it has turned a blind eye to poor behaviour by any provider. I can personally guarantee you, all of you who are watching, that I have personally lodged formal complaints with ASQA in relation to a number of issues of non-compliance and critical non-compliance, misleading conduct, corruption, criminal activity, all sorts of things that have been going on in the sector. I personally have lodged formal complaints with ASQA about these issues, and in some cases I've actually received an email back saying that there was no case to answer, and this dates back several years that I've been doing this. So I want people to know out there that when ASQA says in its statement responding to the 730 report on Wednesday the 6th of November 2019 that it refutes any suggestion that it has turned a blind eye to poor behaviour by any provider, I have got quite a bit of evidence to support the fact that in those situations they have turned a blind eye, and the Australian public needs to know that. Not all of the providers who are being pursued by ASQA are the ones that you would expect to be pursued. They're often the smaller providers just trying to go about their day-to-day business, handing down skills and knowledge in their specialist areas to people to leave a legacy in their industry. And what we're finding is that those small industry specialists are being closed down in large numbers for reasons that are not right. They're not being afforded the procedural fairness that they should be entitled to, and enough is enough. So if at the end of all of this you can honestly agree with us and say enough is enough, or even if you're not sure but you think, you know what, I do have a small doubt and there is a small possibility that some of this might even be true, then I really encourage you to please sign that petition and put your voice out there and say enough is enough. We need more transparency around ASQA's regulatory practices. We're not saying that there's no need for a regulator, because there absolutely is. There is a need for a regulator, but it needs to be done properly, it needs to be done fairly, it needs to be done transparently, and it needs to be done in real accordance with the legislative instruments and the legislation that underpins the vet sector in Australia, because at the moment that is being abused. So I'd like to thank everybody for joining me this evening. We will have some more interviews coming up over the next few days. I believe Alex Schroeder from Vet Prep will be putting up a couple. I will be taking a back seat for a couple of days while I try and spend some time to enjoy my belated birthday. But thank you very much for following. I hope that you found today's video interesting and informative, educational, and that it gives you another example of why enough is enough, and your vote and your signature is critical to the Enough is Enough campaign. Thank you once again for following, and please like the page, follow us on social media and Vet Prep as well, so that you can stay up to date with vet reform activities and the work that we're doing, so that you don't miss any of the interviews that are coming up, and we'll speak to you soon. Bye for now.